Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, here before the Commonwealth. Credit to representatives shall be heard. I'll say the Commonwealth of Massachusetts, floor is open, please be seated.
Good morning, everyone, and welcome to the March 7th sitting of the Massachusetts Appeals Court. My name is Mary Sullivan, and your panel today will consist of me, Justice Sachs, and Justice Ditkoff. All the usual rules apply. Each side will get 15 minutes. There's no rebuttal. You can be assured that we have read your briefs and the record with care, and we urge you to go directly to the heart of your argument. We have a shortened sitting today in person of 3.5 cases, so we will be going directly through all of the cases that we have before us without a break, unless there are any technical difficulties or otherwise with the folks who are scheduled to argue today. So with that said, we'll call the first case, which is 21P0873, Commonwealth versus DELAFUENTES.
Good morning. May it please the court. My name is Esther Horwich. I represent Mr. DELAFUENTES. I would like to address the arguments in the opposite order than I raised them in my brief. First, dealing with the Mr. DELAFUENTES, the Commonwealth's introduction of Mr. DELAFUENTES' testimony that he exercised his right to remain silent before the police, and also their commenting on it during opening and closing arguments. Actually, I have to take my mask off. Sorry. Mr. DELAFUENTES was ordered by the police to stop walking, put his hands on the cruiser. He was frisked. He was subjected to 2 show-ups. He was told to sit on the ground, and he was questioned. What happened? Officer Keenan said, I asked him what happened, and he didn't elaborate with me any further. And Officer Donnelly said, when she asked him, he said to forget about it. Clearly, he was exercising his right to remain silent.
Didn't he tell the first officer that he'd been attacked?
He did. He volunteered that statement, and then the officer...
That's kind of important, isn't it?
I don't think it is to the analysis, because it's the questioning, whether when questioned he exercises his right to remain silent. And when he was questioned, that's what he did. He said, forget about it, or he just wouldn't elaborate. And
Is that the test, though? Can the defendant selectively choose what to talk about and what not to talk about?
not selectively during an interrogation, Your Honor. If he's interrogated, he can't say, well, I'm going to talk about this, but I'm not going to talk to you about that. But if it just blurts something out, and then the police focus in on him and say, we're investigating something, at that point, he can refuse to talk to them.
What's your best case for that?
It is cited in I don't have it, I didn't put it in my notes. It's cited in my brief. I cite a number of cases in which it talks about selectively, and if you look at the facts of those cases, those are during interrogations where he says, I'll talk about this, and then he says, nope, I'm not going to talk about this, but I'll answer your other questions. The similarity in this case is if this were, for example, just because a defendant talks about something, that is not that is not considered as part of the analysis. For example, he talked to the officers about his social life, and that there's a case I cited akin to booking questions. You know, the issue is what is focused on as part of the interrogation that relates to the incident.
What do we do about the fact that defense counsel repeatedly argued that the defendant was talking to the police?
I think that defense counsel, that benefited the defendant not in one way. He was talking to the police, but I don't think that helped, particularly where...
Maybe it helped, maybe it didn't, but where defense counsel's argument is opening that the defendant is talking to the police and he's cooperating, why doesn't the prosecution get to explore the degree of his cooperation?
I think that it could have been explored without bringing out the fact that he stopped talking. because that's
How,
what,
how would you do it without that?
well,
If he's saying, if defense counsel says in opening, as he does, he's cooperating with the police, how do you get out that that's not the case without showing that he doesn't cooperate with the police, doesn't talk?
well, he does cooperate with, to some extent. Defense counsel was not exaggerating. He did participate in a show-up, and that could have come out without bringing out the fact that he did not, he refused to talk to them about what occurred. So there was evidence that he did do that. That was not inconsistent with the facts. So the only thing that showing that he did not participate, did not cooperate with the police, was when he had the right to exercise his right to remain silent, which he did.
Didn't he have the right at all points not to cooperate with the police?
He certainly did. He didn't have to do anything, yet he did cooperate with the police with regard to the show-ups. He was there, he showed up, he came to the police station when they asked him to come to the police station. All of that is completely, is what he did, and counsel had the right to argue that. But the fact that he didn't talk to, he exercised his right to remain silent was extraordinarily important. And he had the right to do that and still cooperate with the police. And showing that he refused to talk, suppose he hadn't said, suppose all of this had occurred and he hadn't, the police hadn't questioned him, he would still be cooperating with the police. But the fact is the police tried to question him, he did not respond. He had the right not to respond, and that's the difference. If he didn't have the right to respond, I think the Commonwealth would be able to argue, well, he didn't cooperate with the police. But cooperating with the police doesn't mean that you have to waive your right against self-incrimination. So the jury heard from two witnesses on that.
Just so I'm clear, the particular testimony you object to, taking Sergeant Keenan to start with, you don't object to Sergeant Keenan saying the defendant stated he'd been attacked?
No.
And then what you object to is, the next question is, what did you say when he said that he was attacked? Sergeant Keenan answers, I had asked him what had happened, and he didn't elaborate with me any further.
That's correct.
So it's just that he didn't elaborate with me any further that is prejudicial.
And Officer Donnelly's statement where he said, forget it. Because that shows that he is not willing to talk to the police.
Does it show he's not willing to talk to them, or does it show he's minimizing, not feeling that it's important to talk about that particular, his ear injury or whatever it was?
Well, it wasn't talking about the injury. I asked him what happened.
I asked him who hurt him, who had injured him, and he just said, nothing, forget it, don't worry about it. That's what Officer Nicole Donnelly testifies.
Yes. And that in combination with Officer Keenan's testimony, I asked him what happened, and he didn't elaborate with me any further, shows that he's not talking to the police. He is exercising his right to remain silent. And in case there was any doubt, then you have Officer Donnelly saying, forget about it. In other words, it's a way of saying, I'm not going to talk to you. I'm not going any further. And that was brought out to the jury. It was argued by the prosecutor. He decided to tell the officers who stopped him outside the bank that he had been the one who was attacked. He decided not to tell them what happened when they asked him, and followed up on his statement.
But it's not as if he doesn't want to talk about anything. That's the next word the prosecutor says.
Right, he talks about...
Responding to defense counsel's argument that the defendant's cooperating.
Well, what he was talking about was he was talking about his girlfriend, his kids, that sort of thing. So the prosecutor was pointing out that he was unwilling to talk about the case, but it wasn't that he wasn't willing to make polite conversation. And he had the right not to talk about the case. And that's emphasized to the jury, as well as in the closing. He clams up. He doesn't want to talk about it. He proceeds to start telling Officer Donnelly about his girlfriends and his kids, anything but what happened downtown. So the prosecutor is laser focusing the jury on this man exercised his right to remain silent.
This is substantial risk that we're looking at, right?
I would argue no. I would argue Mahdi. That was a case that's cited in my brief in which the prejudicial questions about the right to remain silent were brought out, and there was no objection. And the prosecutor argued in closing that the defendant exercised his right to remain silent before the police, and that there was no objection to that. And in Mahdi, the standard was whether it was harmless beyond a reasonable doubt and no reasonable possibility that the evidence might have contributed to the verdict. So that's the SJC saying that this is a standard for when the prosecutor...
Was there an objection in Mahdi?
No, and the court goes out of its way to bring out the facts that there was no objection. So that may be limited to cases in which the prosecutor comments during closing on the defendant's right to remain silent, but that was a standard enumerated in Mahdi. So I would argue that the burden is on the prosecution to prove that it's harmless beyond a reasonable doubt. And in this case, it showed a consciousness of guilt, which...
So in Mahdi, it
Yes.
says, ordinarily defendant is not entitled to appellate review of alleged errors unless his rights are preserved by proper objection, which was not done. We will consider such errors, however, if there is a substantial risk of miscarriage of justice. What am I missing?
But then they go and they say whether it's harmless beyond a reasonable doubt. So it's a bit, to me, I have to admit it's not clear to me, because the normal test would be beyond a substantial risk. But it seems to say in Mahdi that they're putting the burden on the prosecution to show harmless beyond a reasonable doubt, because that's what they say in that case. But regardless, again, substantial risk. Here we have a case in which the evidence of first-degree murder was not strong. In fact, the issue should have been what was the state of mind of Mr. DELAFUENTES. There was no evidence that he premeditated, even ever so briefly, killing Mr. Sabatino. And so the significance of the error is that here it is, here's evidence of consciousness of guilt, and the jury's told to find the highest that they can find, and they hook him with second degree. But that's not the only evidence of consciousness of guilt that sort of came out. There was Mr. Wilder's statement, which I will address in a little bit, but that was also indicative of that. And there was, the problem that Mr. DELAFUENTES was left without a defense at all, because counsel argued self-defense and didn't even once mention reasonable provocation as a mitigating circumstance.
How do we know that the defendant didn't ask his lawyer to do an all-or-nothing strategy?
We don't on this record, but I don't think one can assume that you can a defendant can control an attorney, force an attorney to argue that a hopeless case when there is a potential defense. Any competent attorney would put something on the record.
Well, if a defendant says, I don't want to do jail time at all, I want an acquittal or nothing, that's what I want you to argue, wouldn't a reasonable lawyer at least take that preference into account, objectives of representation and all?
Sure, and might devote just a single sentence to saying something. But you can't just ignore everything and argue a completely untenable defense, which is what occurred in this case.
Why can't you? I mean, the defense lawyer's obligation is to engage in zealous representation of his or her client. The client, they're fully informed, and this is the problem with not having a motion for new trial.
Yes.
Put a letter in the file to the client saying, I don't agree with this, I advise against it, but I'll follow your instructions. Why doesn't the defendant control his own defense?
The defendant at that stage there might be an irretrievable breakdown, because you can't go on a suicide mission for your client. You just can't.
Why can't you if the client directs you to?
Because you have an ethical obligation to represent him. You can't.
Right.
You can't. Say the client wants you to stand up and tell the judge that the judge is worthless, the jury's worthless. You can't do that.
You're in a different world there, and you might seek to withdraw based on irretrievable breakdown. But the notion that my client wants me to proffer a defense, which in my professional opinion is not the most successful, is a judge going to grant that?
Well, I think that this is a situation where the attorney was going on third-party culprit defense until the day before trial. I mean, day before the jury charge. He still wasn't really sure of what he was doing then. And he was telling the judge, well, you know, I think I want a self-defense instruction. I haven't quite decided. So he was taking it on as if he was the one making the decision.
Of course, that's what you do, right?
Well, if there's a problem, you can tip a court outside the hearing of a jury that the client wishes you to argue self-defense, and that's what you're going to do. And
you could, but do you have to?
I think you should.
You have to
Otherwise,
reveal?
you're at risk of getting, you know, in hindsight, the client coming back and arguing. And
That's why there's a letter in the file.
Pardon me?
That's why people put letters in files to clients.
To clients, but if you're making your decision on a Friday and you're not sure of which way you're going to argue it, you may not have the time to write the letter to the client and get it received.
You write a note in the file. But
Right, you
people
can
know
write a
how
note, you can write a note in the file, but it's not uncommon, again, to say, Your Honor, my client wishes me to argue this, and I'm going to argue this. And you're not saying, I think it's right, or I think it's wrong, but you're letting the court know that this is the argument. But in this case, there is nothing to indicate that the client forwent.
Ineffective assistance is not unmistakably clear from this factual record, is it?
Ineffective assistance is, actually, I think it is, because I don't think there's anything that indicates that it is not. In other words,
well, if there are questions about his strategy,
well,
how can we decide on this record?
There are cases that say it's manifestly unreasonable to forego a viable strategy for one that is not viable. And if you're going to do that, you need to put something on the record as trial counsel. But that's what this attorney did. And he took, instead of arguing a viable strategy based on the evidence, would have been the manslaughter based on reasonable provocation, because the evidence was there. That was the only thing the evidence was there for. There was no evidence that would satisfy self-defense. And in the 71 pages of jury instruction, he needed to focus the jury on what the alternative theory was, and he didn't even do it. He didn't even mention it. And because he chose a path that there was no hope of success, I would argue that even if the client had told him to do that, that's not something that is reasonable to do. You're just telling the client, I mean, if the client had said, I just want to blame the victim now or do this, you might say, well, maybe I can put a sentence in here or there, but you can't forego a viable strategy.
Are there any other questions? Okay.
Thank you.
Your red light is blinking. Thank you.
Good morning. May it please the court. Kenneth Steinfeld for the Commonwealth. There's no selective right to silence here. The defendant talked about anything and everything except for how he got the laceration behind his ear. He said that he got attacked. He talked about his girlfriends. He made very clear that he was willing to talk to police, just not about one subject. And that, I think, of the defendant here is trying to get away with sort of a reverse Odell violation. He wants to pick and choose which parts of that conversation he can have in and not have the jury be told that he would not talk about one aspect of it. He did answer what happened back there, which was the key question, I got attacked. He just didn't want to explain how he got the laceration behind his ear. So he basically wanted to warp that conversation that he had with the officers to make it look like he was fully forthcoming. And I strongly disagree with my sister that the counsel made very good use at trial, both in opening and in closing, that he was forthright, he spoke to police, he didn't run away, he talked to them, he engaged with them, he just would not speak about how he got the laceration to his ear. And I've cited 5 or 6 cases that are very similar, directly on point, in which a defendant doesn't want to talk about one aspect of the case, but does talk about another, and that is simply not a violation of his constitutional right to remain silent. And I think, as this court has pointed out, the claim is certainly waived. There's no objection below, so it's a very straightforward waived constitutional claim where the standard of review is a substantial risk of a miscarriage of justice. I'd also point out that the defendant moved to suppress that conversation, and in a pretrial ruling, the judge found that that was not a custodial interrogation. So to the extent that there's any implication that he was forced to be there and forced to answer those questions, the judge has already rejected that claim, and that is now before the court. As to Justice Ditkoff's point about an all-or-nothing defense, I think it is very fair to say that had the jury found him guilty of manslaughter, that this was an extremely serious manslaughter case, that he was likely to get a term, a prison term at the high end of the range, that is from 18 to 20, something like that, because of the circumstances of the case. And I'd also point out that is also indicated by the sentence that he did, that Judge Dressler did give out for the second-degree murder. It was life with parole eligibility after 25 years, not 15. So he clearly saw this as a very, very extreme case of either second-degree murder or manslaughter. So if defense counsel had said, find him guilty of manslaughter, and here's, in her words, to marshal the evidence of manslaughter, then he was certainly going to be looking at a heavy manslaughter sentence, plus probably consecutive time for the crimes against Danny, which were separate and indistinct, as to which he was convicted of armed assault with intent to kill.
What was his record like?
Pardon me?
What was the defendant's record like?
That I don't know. I don't think it's in the record.
I wondered when it came. I don't remember from the sentencing transcript whether it was mentioned.
I don't believe it was, but I'm not.
Not looking outside the record, just wondering what was.
Yeah, no, there is something in
No,
the
I try to limit myself to knowledge of what's in the record, so I don't say something that's not.
Absolutely, and I wasn't asking you to go outside the record.
Okay, good. But of course, we do know that he gave him the 25-year, first eligibility, which I think speaks volumes, as does the evidence in the case.
Well, and he gave him on and after for the crimes against
Yes,
the
he
other.
did. So there's every reason to believe that he would do that for manslaughter as well. So he's basically saying, my lawyer should have asked for something that would have gotten me 25 years in jail, maybe, perhaps more, instead of seeking an outright acquittal, which is what a self-defense defense would have done. And I think it is absolutely not clear from the face of the record that he was ineffective when he did that.
Forgive me, but what's the maximum for manslaughter?
20 years. So
it's a 5-year delta,
yes,
either way.
yes. But
If
still,
you-
as I said, I've seen similar cases in which an 18 to 20 or 16 to 18, something like that, is a viable sentence for a very serious manslaughter that approaches, or, as the jury found here, was in fact second-degree murder.
If you could just return to your first argument for a moment, you heard defense counsel make a distinction between selective disclosure in the course of an official interrogation versus selective disclosure at the moment of the first conversation, shall we call it. How do you respond to the notion that we should draw a distinction between those two sets of circumstances?
I don't think that there is any distinction, that in neither situation, either during a custodial interrogation nor at a roadside encounter, which is not that a defendant has the right to pick and choose which questions he's going to answer. In either case, he has to make an unequivocal assertion, an invocation of his right to remain silent. So I don't think that it much matters whether or not he's being interrogated custodially or just having a conversation on the street.
Do you have a case for that?
Yes, the cases that I cite, there's a string cite of cases, and some of them, and for the parentheticals it's clear which one, involve custodial interrogations,
right,
and some of them don't. No. So that string cite has cases of both types.
Both briefs have string cites. I was just wondering if there was one in particular, but that's fine.
No, just I know that it's there, so I didn't.
Right, that's fine. that's fine.
So it's all there. And of course, there's no affidavit from trial counsel, which I think makes it almost impossible for this court to conclude that counsel was ineffective for his decision to seek instruction on, to seek a total acquittal on the self-defense. He argued he made the best of what he had. The judge allowed him to argue self-defense, and he argued that because of the defendant's statement to the officer that he had been attacked and because of the testimony from Mr. Wolf that there had been a scuffle involving 2-on-1, he had something there to work with. Maybe not a lot, but he had something to work with. So it was not manifestly unreasonable for him to ask the jury to find him not guilty altogether on the indictment for second-degree murder, rather than to find him guilty of manslaughter.
He got the manslaughter instructions, right?
Pardon me?
There were manslaughter instructions, were there not, on reasonable provocation?
Yes, there were. He
So
got all three, as a matter of fact. I'm sorry, Your Honor. He got manslaughter by excessive force of self-defense. He got manslaughter by reasonable provocation, and he got manslaughter by sudden combat. Even though, as I argue, there was little or no evidence of any kind of provocation by the fatal victim directed at the defendant, thereby making that case extraordinarily weak, weaker than the self-defense case, as to which at least he could argue from these little things that there was some kind of a fracas or a scuffle. So really a manslaughter, and in one of the cases I cite, had the defense lawyer done just that and said, please find him guilty of manslaughter, his lawyer may be here today arguing, I can't speak for, saying that he should not have foregone that and he should have sought acquittal based on the total self-defense of self-defense. So I don't think that he can have it both ways. And
I guess my question was, can it be reasonable when you know an instruction is going to be given on manslaughter by reasonable provocation to argue for self-defense, to, ask for the moon, realizing that the jury is going to be given the option of something in between, not explicitly arguing for it, but trusting that the jury is going to follow all the instructions and go down from the most serious to the least serious, and that they'll consider that whether you ask for it or not. Is that can that be a reasonable strategy, or do you have to ask for it?
I'm sorry, do you have to ask for the instruction or
No. Do you have to ask the jury for it when you know the jury's going to be instructed on it anyway?
Well, no, he focused on what he thought was his strongest defense, and that is self-defense as a complete defense. Sure, the jury are told that they can find him guilty of manslaughter, but there's no case I'm aware of that says that a lawyer has to argue both in order to be effective. He doesn't have to say, well, there's this self-defense, but if you don't like that, then you can also do manslaughter, and perhaps you should. That's a reasonable strategy to have the jury have those options available to find manslaughter if they want, but to focus his closing argument, which is the last thing that they're going to hear, and he wants an acquittal for his client on the murder indictment. And I think the evidence at trial was stronger on self-defense than on manslaughter. Had he argued manslaughter, then the easy answer to that was the lack of any provocation by Matt directed towards him. His failure to try to, to leave the scene, to use any means of escape. So he had much stronger evidence of self-defense than he did of manslaughter. So I don't think he has to argue that at all to the jury. And of course, the jury had that as an option. So as the SJC said in Eng, that came out earlier this year that I sent in a 16L letter, he got the benefit of boons that he's not entitled to, and that is instructions on manslaughter, because the evidence did not permit a reasonable doubt of a bunch of elements of provocation. So he had that benefit, so the jury certainly could have found it, but the defense lawyer was not obligated on pains of being found ineffective to argue all possible defenses to the jury. And I hope that answers your question. Unless the members of the court have any further questions, I'll be happy to rest on my brief.
Seeing none, thank you very much.
Thank you.
All right, the next case is 22P0056 Commonwealth versus Wilson. The Commonwealth has submitted on brief. Welcome, Attorney Yellen.
Good morning. Charlie Yellen for Amy Wilson. Your Honors, in the narrow circumstances of this case, you should reverse for 3 reasons. The defendant has alleged facts that, taken together with the police report, add up to state action. That's number 1. Number 2, the Commonwealth has failed to carry its burden to show attenuation or consent from the time Ms. Wilson is sent to the hospital to the time of the blood draw. And third, the decision by the judge on the motion, denying the motion for reconsideration, just does not present you with a sufficient basis for affirming.
Well, you started out by saying reversal.
Yes, so
You're not talking about entering judgment for the defendant, are you?
No, I'm talking about, well, first reversing and then suppressing the blood test. A new trial or a hearing to probe more about the question.
Can we suppress on this record, or do we need more evidence?
Well, I think you can suppress on this record. You could decide that you need more evidence as well.
Maybe I should start with this question. Do you agree that if, and it's a big if the police did not require the defendant to go to the hospital, then there's no state action involved in the blood draw?
Correct.
And there's no issue regarding its admissibility?
Correct.
Okay. So the focus, at least at this level, is purely on the circumstances, whether she was required to go to the hospital, and presumably, if they required her to go, but that's not a Fourth Amendment violation or an Article 14 violation.
Well, I think this was state action. It requires consent. Consent to go to the hospital, consent for the blood draw at that point, once she's sent to the hospital.
Wait, but which one? Consent to go to the hospital or consent to the blood draw?
My argument is that she did not consent to go to the hospital, and therefore, I think consent is required for the blood draw at that point.
Was the issue of consent to go to the hospital raised before the motion judge?
Absolutely, Your Honor. I'm talking about the hearing on the motion for reconsideration. In that hearing, the judge made clear, after some discussion, the judge made clear, and counsel agreed.
But it was at the motion for reconsideration,
Yes.
which was non-evidentiary.
That's correct.
Is it adequately preserved if it's raised on a motion for reconsideration? Because at the time the evidence was taken, no one was on notice that this was the issue.
Well, there was no evidence. It wasn't an evidentiary hearing at reconsideration.
Right.
The judge said the focus of this motion is on whether the defendant consented to go to the hospital. And to find that out, the judge said, I need an affidavit from the defendant on just that point, whether she consented to go to the hospital. I'm going to review that affidavit, and then I'm going to make my decision.
Why doesn't the judge have the discretion to just deny a motion to reconsider that raises new issues?
The judge has discretion, of course, but the judge requested this affidavit on exactly this point. And then in the decision on the motion, in the decision denying the motion for reconsideration, the judge states what she reviewed. She reviewed the motion, the arguments in the hearing, and the police report that she accepted as an exhibit. She didn't mention anything about this affidavit. She said, there's no state action here at the accident site. There's no state action. But that's what the affidavit states. It makes out a case for state action. You could read it if the judge said, I read all the papers, denied.
Well, but I mean, a judge could reconsider based on new issues, but why does a judge have to reconsider?
The judge The judge doesn't have to reconsider. The judge could have said denied, as I said.
This is what the judge said.
But the judge has to give you, listen, this is we're not talking about a parking ticket here. We're talking about a deep-seated expectation in privacy that the defendant has. You need a clear and complete record of what was decided below.
Which was the defendant's obligation to make and didn't make at the original hearing. So let me...
The judge asked for an affidavit.
The judge asked for an affidavit that the judge doesn't have to credit the affidavit. Let me ask you a different question. Could the police have called for an ambulance in the exercise of a community caretaking function, and if so, did that require consent?
No, the judge can call for an ambulance. I'm sorry, the officer can call for an ambulance, of course. The question is whether that contact ripened into something other than community care.
And if the defendant gets in the ambulance and goes to the hospital, is that an improper seizure?
Well, now we're talking about why she got into the ambulance, and she alleges facts that says, I felt I had to do what the police wanted me to do. She could say to the emergency workers, technically she could say, I don't want to go. I don't want to go.
Well, the police have probable cause to arrest her, right?
Yes.
So they can transport her to a prison, and they can transport her to an infirmary, or they could transport her to a hospital.
Once they have probable cause, though, I believe they need to get consent for the blood test.
Well, that's a different issue.
Not to go to.
Well, it's a different issue.
Not to transport to a hospital. They can transport wherever they want once they have probable cause to arrest her, right?
Yes.
Within reason.
Right. Okay. So they still, at that point, they need, we don't have the nurse, unfortunately. We don't know what happened. The Commonwealth puts, when we're talking about attenuation or consent, the Commonwealth puts all their weight on this consent form. This consent form won't suffice. You put a lot of stock in the times that are entered into medical records. We think that's rock solid information. Well, those times show that this blood was drawn 12 minutes before she signs the form for procedures that are about to be performed. That's
Can we
not
just
the
back
kind
up
of
a
consent.
second? If the police have probable cause to arrest her, then what poisons the tree that you say this blood draw is the fruit of?
Well, I think if we're going down that route, the probable cause route, then I believe they just they've got to show consent to the blood test. But I'm not sure that's the poisonous tree.
But they have probable cause to arrest, and they ask the ambulance personnel to take her to the hospital. They don't tell the hospital personnel to do a blood draw. Simple but for causation, they had probable cause to arrest her, they sent her to the hospital, and then it turns out the hospital did a blood draw. That's not enough to create fruit of the poisonous tree, is it?
No, but
there has to be, if it were state action, if it were a police hospital, that'd be one thing. But here we have probable cause, and then private action takes over. Doesn't there have to be some kind of closer causal connection to what the private actors do in order to turn what they do into state action, or to create the connection between the tree and the fruit?
Well, I think that if there's probable cause that the police there still needs to be some consent to the blood draw. It's not a poisonous tree analysis, I think, at that point.
So why does the 12 minutes matter?
I'm sorry?
Why does the 12 minutes matter? I hear your argument.
Oh, the
but
12
why
minutes
can't
matter
she,
because...
If I could finish.
Oh.
Why can't she retroactively approve what has already been done? Why do you say the consent is only forward-looking in time?
Well, because I think that we need if we're talking about actual voluntary consent, and we're doing it in the context of such a deep-seated privacy right, I don't think you can do this. I don't think something like this consent form can suffice where you're, first of all, the form itself is for procedures about to be performed. What are those procedures? Routine procedures. In the dentist case, they had a form that was even a little bit more specific.
Well, the dentist case is different because that was
Well, I know, but
police directed.
Okay,
So,
but just
This is
just
a routine medical form. I mean, they also performed, I think it was a head CT and a cervical spine CT on her. Are you saying those were unauthorized or
No, I'm
unnecessary?
glad you raised that. Because if you contrast the consent that she gave for the, so-called consent she gave for the blood test with the consent she gave for the CAT scan, they explain the risks to her, she agrees to it, they go forward with it, it's clear in the record. And that's for a far less invasive procedure, Your Honor. And
Again, I want to be clear. If the police had had nothing to do with her getting to the hospital, if she just got up from the accident, police said, you're free to go, she went to the hospital to get herself checked out, and they took blood, even against her will, does that need to be suppressed? I mean, there's no state action there, right?
No.
So, and you conceded before that there was probable cause to arrest her.
yes,
So then, does everything that follows where does the poison come in? If there's probable cause to arrest her,
well, so there's two ways to look at this, I think. If there's probable cause, that's one way. Probable cause, she needs, the police need consent to the blood test.
but the police didn't take the blood test.
No, but
Unless the blood test was something that the police asked for, or I don't know what the standard is. Does it merely have to be reasonably foreseeable? Is it something, there's no illegality for the police to exploit here if there was probable cause to send her to the hospital.
Well, I still think they have to have some consent to the blood test at that point, or get a warrant for the blood test.
But why? If isn't the blood test purely the product of lawful police action in sending her to the hospital, plus lawful private action?
Well, if she went to the hospital based on probable cause, she was sent to the hospital. They could have arrested her. They send her to the hospital. And she said, I don't want a blood test. They have to get consent to that blood
But
test.
if they didn't get it, but if they took it anyway, that's not state action.
Well,
I mean, if the police took her to the hospital, we're arresting you, but we're going to take you to the hospital to get checked out. And the police go to the hospital and say to the medical personnel, whatever you do, take good care of her, but do not draw her blood.
the police say that?
If the police say that, and then the medical personnel go ahead and draw the blood, does that have to be suppressed just because the police brought her to the hospital?
I'm not sure. I'm not sure how to answer that. I think that
There has to be some causal connection that's more than a but-for connection between the police bringing her or causing her to go to the hospital and the drawing of the blood in order to subject the blood draw to a consent analysis for purposes of suppression. Doesn't there?
Well, I would just turn the attention to the fact that she's saying she didn't want to go to the hospital. She was saying she felt fine. She probably couldn't say that she didn't want to go to the hospital, and that's why she was sent to the hospital.
I don't know what the rule we would issue here is. Will we rule that if the police transport you to a hospital, a nurse can't take a blood draw without the nurse getting a warrant or getting constitutional consent?
I think there was ample opportunity for consent. There's 40 minutes. The
Right, but I
police
mean,
can.
are we supposed to tell nurses and doctors how they have to practice medicine when the police transport someone to them?
Oh, I think the police had ample opportunity to get consent. There's 40 minutes between the time she's sent to the hospital and the blood draw.
But if the police aren't causing her blood to be drawn, they're not making the decision to draw her blood. Why do they need to get consent? Where's the state action in drawing her blood?
Well, they know she's sent to the hospital. They have probable cause. They think she's intoxicated. They've got all this time.
Do they say that to the personnel at the hospital?
No, they know it.
Do they do anything to, beyond bringing her to the hospital, to cause the blood to be drawn?
No. They don't do anything. What they should have done was, in that 40 minutes, called ahead for a warrant or made some other effort to get consent.
So you're acknowledging that the police didn't do anything at the hospital to cause the blood to be drawn?
I'm acknowledging that there's no evidence that they did. If there was a hearing as was requested, then perhaps we'd be able to probe that more.
The judge says that the medical professional said she was clinically intoxicated and that they needed an ethanol level in order to know how long to keep her in the hospital. I think there's a representation in one of the briefs to that effect. Is that your memory, and do you know where that is in the record?
Where that's in the record? Yes, it's in the impounded record appendix, I believe at page 39 or 40.
Thank you very much. That's very impressive.
Thank you.
And your red light is flashing. I promise you we would have had equally difficult questions for the Commonwealth. All right, the next case is 22P 0056, Commonwealth, 22P 0693, Commonwealth versus Powell. Is it Attorney Renaud?
Yes, Your Honor. Good morning. May it please the Court, Suzanne Renaud for Aaron Powell. Your Honors, ultimately this case came down to the authority to pat frisk Mr. Powell. And the only way that could be is if the police thought that he was armed and dangerous, and the only way that could happen is if they thought that they reasonably suspected him of committing the underlying crime here. The problem is that is not supported by this record, that reasonable suspicion that he committed this crime is just simply not there. I'm going to start with the officer, because this brick flyer communicated something to fellow officers, and Detective Medina, I believe it's on page 37 of the transcript, when asked if he had any suspects, he said he did not. If there were any description of the people, he said that there was not. So we don't know how many suspects there are, their age, their gender, their clothing. We don't know a thing about them. That contrasts with a host of cases that have come before the court that are different, where you have suspicion and a description of, say, a vehicle, but also at least some kind of bare bones, any description of the perpetrator. So, Ancrum and Lopes and all of those kinds of cases. They're very distinguishable because you have at least something. But here, this reasonable officer communicated in the flyer that he put together, we don't have suspects, said FIO these suspects, which by virtue of the prior case law, we know means that means a consensual encounter with the suspects if you come across it. They said, the woman who owns the car, the registered owner, we don't have any suspicion on her. That's what follows here. Had they done some investigation about people she normally lent the car to, that might have been different, but they didn't. I'm sorry, Your Honor.
These things seem a little overstated, but maybe I'm missing something. Do we affirmatively know they have no suspicion of Kayla, whatever her last name is?
It said, it's registered to Ms. Evans, and it says that occupants were possibly involved. And when he was asked on page 37, he agrees that the flyer states that there was no suspect wanted at the time, and also that they had no information about the alleged shooter. I believe elsewhere in the transcript, and I'm sorry I don't have it here in front of me, that he did actually also say that they didn't have suspicion of her. But when you piece these things together, if we have suspicion of no suspects, that also means we have no suspicion of her. So, and the issue here...
hold on, wait. So a suspect not being wanted at this time isn't the same thing as saying there's no suspects.
Yes, it is, Your Honor. I would say that was what was reasonably communicated, and that's what the other officer who testified believed. When he said that they have no information about the shooter, that means we also have no suspects. I mean, you can't, without any information about who the people are who are suspected, there is only one thing that that can lead to, is that we have no information, that there are 0 suspects that are known or wanted at this time. So, you know, I think that I'm not really sure how else that could be parsed together. If they had any information about the suspects at all.
Where does it say they had no information?
We have no information about the alleged shooter on page 37. And he agreed that the flyer stated that there was no
information about the
suspect
alleged
wanted.
shooter, I see, correct. Yep.
So, and he's the person who put it together. So he's basically conceding, we know nothing. We know nothing about who these alleged shooters are. So there is a vacuum there about those people. They know that there's some potential suspicion about the vehicle, whether it be that the instrumentality of the crime would still be in it, although that would be a little bit far-fetched 36 hours later, especially since there is legal propositions that say guns are usually stored in the home. But regardless, it still might have evidence. It might still have gunpowder or whatever else. So I'm not contesting about the car. But here we are, because the second factor that you have to take into for reasonable suspicion isn't just the suspects. It's also the time aspect. Those are the two most important ones here. 36 hours later is an awfully long time. One was in the middle of the day, 2:22 p.m. The other one is right after midnight. This is an enormous gap in time. So to go from not having any suspects in the middle of the day on a car where it appears that they don't have any suspicion of the registered owner, that the person who was driving the vehicle at that time would still be driving it or in the vehicle 36 hours later is an enormous gap. So, you know, I was thinking this through. I'm like, are there ever any times where you could say, oh, we suspect this vehicle, and without having any description?
The vehicle is armed and dangerous is essentially the mindset here,
but
with no information about the occupants. And pre-Taurus Pagan, that might have been enough, right?
It might have been, although Manaus says it would not have been, Your Honor.
So, but we don't go there because now we have Taurus Pagan.
Right.
So my question to you is, what were the police supposed to do? They know that this car was involved. They know as best they can at the moment. They reasonably suspect, they really suspect that this car was involved in a shooting in broad daylight on the afternoon before.
Yes, Your Honor.
And there's 2 people in the car, spotted by a plainclothes officer, waits for backup. Assume for a moment that based on the BOLO, they can issue the exit order. What were they supposed to do with the 2 people in the car once they issued the exit order, knowing that their colleagues have a strong suspicion that this car was involved in a shooting?
Now, first of all, Your Honor, again, the time minimizes whether or not the actual gun would still be in there. But I think that I want to analogize it maybe to a search warrant case where there's a suspicion about a location involving drugs, but you don't necessarily know, any of the people who would be in there. And a search warrant that doesn't have any person present. If police go in there and they encounter people, of course they're not supposed to put their safety at risk, but they're not supposed to pat frisk them either.
How do they protect themselves?
They can move them to the side. They can put them in the handcuffs. In fact, I was looking at one case, Commonwealth versus Varnum, I don't think I cited it, but where there was a police safety issue, and they handcuffed people at the side of the road in order to protect police safety. Yes, they could do something.
How does that work when the bulletin says impound the car? They know that all that's going to happen is that this car is going to get towed away, right? So on what basis do you handcuff people whom you're going to release?
Well, Your Honor, I would say that they didn't need to take those steps, but when you're asking about the question of officer safety, bringing 12 officers, or however many it was, to vastly outnumber the people, that's a protection of officer safety. Separating the 2 people.
If someone's got a gun, then the fact that there are 12 officers there, if they're not allowed to pat frisk them, how much protection is there for the first officer who might get shot?
But Your Honor, they're presumptively innocent, and I think that's the problem. That's what Taurus Pagan tells us.
Judge Sullivan's question But Judge Sullivan's question was basically, how are the police supposed to protect themselves? And you offered the option of they can cuff the suspect without pat frisking him?
Which has been done in other cases, yes, Your Honor. And it's been done in search warrant cases. I guess my point is, yeah, there certainly is a tension here. But we do know that automatically pat frisking somebody just because the area that they're in potentially, and again, I think not even 36 hours later, strongly, has a gun in it, doesn't give license for the presumptively innocent people to have the very intrusive amount of pat frisking. There are other things that police officers could do to protect their safety.
I understand your argument. Let's say they pulled them out, separated them, and did not immediately pat frisk them. And they turn to the driver and they say, license and registration, please. And she says, oh, let me just reach in my pocketbook to get it. Do they have to let her reach in her pocketbook to get it? Or are they allowed to look in the pocketbook?
That's a very good question, Your Honor.
Or if they turn to the passenger and say, what's your name? And he says, I'm so-and-so. If you let me, I'll get my wallet. Do they have to let him get his wallet?
Well, I think that would certainly be something the police could allow, I mean, because they would want to get identification.
Of course they could, but do they have to? Or can they pat frisk him before he reaches into a pocket?
At least just the pocket.
I think in a case like that, unless you have a suspicion that the person is armed and dangerous, which again, you don't, you would not be able to pat frisk them before they reached into their pocket. That's just simply the answer. Because the problem is that until you make a connection between these people and the firearm, and they have not made that connection between these people and the firearm, you cannot presume that they're armed and dangerous. The fact that they were in a vehicle that at one point must have had a firearm in it 36 hours before, but it's absolutely unclear that it is these people who were the ones who were in the car. Those are a bunch of hunches. They are a bunch of suppositions that you are making. And again, I understand the concern for officer safety.
Yeah, I don't think we're talking about reasonable suspicion at this point. I think we're talking about officer safety. And what do you do when the car is armed and dangerous, but the occupants are unknown?
Again,
it's an interesting delta, because I don't think we've seen this since Taurus began.
I don't think so either, Your Honor. And I think, going back to those search warrant cases, and I unfortunately did not cite to any of them in the brief, and I don't think the Commonwealth did either, but there are cases where police come in and they're allowed to seize the people. I just had an unpublished case that kind of dealt with like whether an occupant could be seized, and then, but whether
there are.
So it's not we're not on uncharted territory completely, where we're dealing with the location versus a person and safety when the police have to enter into a location. So I think I think it does bring up interesting issues and how far you're supposed to go, but I think the law is absolutely clear that pat frisks for officer safety are not allowed on the surface. And once you start from that premise, even though you can kind of walk down like a bunch of different scenarios, you're not permitted to do it. Now, I will again tell you this unpublished case that came out, I think it was December 20th, that I argued, where the police, it was a search warrant case, police seized the person, and in the course of seizing them, they felt a gun, and then they could pat frisk them. So, maybe something like that, that's where you have individualized suspicion. But that wasn't this case in any way. I mean, you've seen the videos, I'm sure, where you could see that, you know that my client was coming out of a Chinese food restaurant with his hands full of food. That's when the officer first saw him. He never even had to get into the car in the first place in order for him to be separated from the car where they presumed that there was
backup there at that point? In fairness, this is an off-duty police officer who's called in and called for backup, wearing his Red Sox shirt.
Yes, Your Honor. There are other videos, and I think that there were, but those are not before the court. So I guess I can't go too far down that direction at all. So I apologize for bringing something that might have been out of the record. But that is, So, but he had food in his hands when they opened the door. They said, oh, no, don't worry about it. I'll take your food. I'll just place it up here. They said it nice and calmly, and then they pulled him out and they pat frisked him. So this wasn't a scenario where they were trying to do anything else other than pat frisk him. They decided to do it right at that moment.
Did they ask his name before they did it?
They did not. They asked it afterwards, I think. I think they went to him immediately and just said something about the food. I could check the
evidence?
facts, but they're in the facts section that I wrote up, Your Honor.
Is there any evidence that they knew who she was at the time
They did not know who she was, apparently, at the time. I think that there was a suspicion. I mean, I guess you could say, a female owner, like registered owner of the car, and therefore she would likely be the owner. But I don't think she was. And I'm sorry that I don't have the record in my head. I don't know that she was ever even identified by the police officers who testified as being the registered owner, ultimately. I don't think they said it on the record. I believe it was her, but I don't think that would have been the presumption that she was, in fact, the registered owner.
I'd like to shift gears for a minute, just a little bit. There's information in the BOLO that there was suspected gang involvement. Were they permitted the police permitted to rely on that? Was there any evidence of it at the suppression hearing, and may we rely on it?
My understanding is they did not rely on it. The judge below didn't rely on it. My sister here did not argue it. There was no mention of it at the hearing whatsoever. And I think in my original brief that I've dropped it in a footnote that it should not be relied on because it was simply not supported by anything on the record here. They didn't know who the suspects were. They didn't say that the people who were the victims were involved in a gang in any way. They just never made any kind of connection between those two things. And I just want to also point out one last case, if I may, Your Honors. I think the Jordan case that I cited in the reply brief kind of gets it's the most equivalent of this case. You had a person who was not the registered owner.
Rental car.
I'm sorry?
It's a rental car.
It was a rental car, but here, if Ms. Evans, that's the only difference, but Ms. Evans is the registered owner and she's not suspected, so whoever was the alleged shooter would have been a non-registered owner, and it was also the time gap being 48 hours or 2 days in that case, and this one is 36, and which is just a really significant amount of time that would have minimized any kind of connection between the people in the vehicle and the illegality that had occurred itself. Unless the panel has any other questions, the rest of my brief. Thank you.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. I think if we could start just with the pat frisk, because I think this is the nuts and bolts. I think the exit order is clearly squarely in Torres Pagan, the third prong that allows for a search that's of the motor vehicle. The occupants have to be taken out. And I think
If I could just ask, is there anything in the record to indicate whether there was a warrant awaiting them?
No.
And it doesn't
nothing-
matter because nothing was found?
Yes,
Okay.
I agree with that in the record. And I think
Thank you.
at the end of the day, I think this really comes down to whether or not it's appropriate when the officers are about to do this pat frisk. Is it appropriate to divorce the criminality associated with the car from the occupants as they do that? And I think to suggest that the police should either ignore or divorce that criminality, again, as we know, it's a shooting, violent crime, the daylight. I think not only is it unreasonable, dangerous, and it's not supported by the tenets of Fourth Amendment law that rely on proportionality in the totality of the circumstance. So I think what my sister is proposing is that the police should have just seen these occupants of this car as people that have nothing to do with this car. And I think Justice Sullivan was kind of describing that this car is the criminality, right? Or has this criminality associated with it, but it's not as if the shooting was affected by the car, right? There has to be occupants that conducted that shooting, right? So at the end of the day, what the officers are investigating is a violent crime involving a firearm, and they are going to impound this car that is not only evidence in the crime, but could also house evidence of the crime, in this instance, a firearm. So to suggest that the officers have the authority to investigate this violent crime with a firearm and not take any precautions to make sure that firearm that could be hidden inside that car by occupants, whether or not they're suspects in the shooting, I think is...
Well, that's cured by the exit order. Right?
Yes, but it's cured by the exit order, but now they get out.
Pat frisk.
I'm sorry, can you say that?
Talking about the pat frisk.
Yeah, we're talking about the pat frisk. So in this case, but now we're having these occupants that the officers suspect, even if they don't at that point aren't sure if they're armed and dangerous, because we're dealing with reasonable suspicion. And I think a lot of my sister's argument was arguing more than reasonable suspicion. But if we can turn back to what they're supposed to do in that instance, they're exiting people out of the car to investigate this, and now they're interacting with people that were just in a car that could house a firearm. So they can take precautions to make sure that firearm isn't turned on them. And I think that's what this really...
Do they have reasonable suspicion that the man they're ordering to get out of the car has the firearm on him?
Well, I think if we look at the facts of this case, I feel like, or I should suggest that the fact that they're investigating a crime that involves, the very crime itself has to do with someone being armed. So the fact that there's occupants in a car that was effectuated a violent crime with a firearm, in and of itself is reasonable suspicion. And I think, in a way...
You'd agree that if this bolo went out, but no one ever spotted the car till a year later, and the same scenario unfolded here, there wouldn't be reasonable suspicion that the occupants were armed and dangerous?
I think that would be a much more difficult argument that I would not want to make before
And then if the car was spotted an hour after the shooting on the 22nd, you'd have more. So what makes 36 hours reasonable?
Well, I think the fact of it is that we're dealing with a firearm, and I think there's much case law that talks about the durability of this good, that it's evidence that's difficult to get rid of, and that
you're not going to get rid of it, but there are plenty of places you can put it. And
Right.
if the firearm was used to accomplish a shooting from a car, and the car was seen in broad daylight, maybe the car is not the smartest place or the place most reasonable to suspect that the firearm would be kept.
Absolutely, and I cite to Hernandez in my brief that dealt with exactly that problem. And again, because we're talking with, or that factual hypothetical, that the police officers are dealing with probabilities, right? We're talking about reasonable suspicion. We're talking about the bare minimum. We're not talking about probable cause. So these officers aren't looking, if you will, to necessarily arrest these occupants. They're looking to ensure that the seizure and the proper impoundment of the car is safe.
What if there were 4 people in the car? Well, we don't know how many people were in the car when the shooting was accomplished, correct?
We don't.
Okay. So if there are 5 people in this car, would it be reasonable to pat frisk them all? When it was, the police found it in front of the restaurant?
Yes, and I think part of my answer is that in this case, there's no, when everyone's getting out, in your example, 4 people get out of the car, there's no protective sweep done of that car, right? There's nothing to ensure that a gun could have been concealed in there, and those occupants, upon their exit order, didn't take that gun out of that car. And I think part of the facts in this case specifically are that when officers approach him, his lap, there's Chinese food on, and this is in the video. So officers are approaching for a valid exit order, and they come upon an occupant in a car that was used in a shooting. They have reasonable suspicion that evidence from that crime could be in that car, and now his lap is obscured.
Okay,
He
so
could
they
be
say,
sitting
give me
on
your
it.
food, I'll put it on the roof, buddy. And they ask him to get out. Why do they have to pat frisk him then? And I would like you to address why cuffing them for officer safety without pat frisking them isn't a sufficient sort of middle ground here.
I think it really comes down to what are officers required to gamble when they're appropriately executing within the investigation within the bounds of their authority. And I think what happens in this, if we have the body camera footage, and you can see how this unfolds. And I think the fact that officers have other options doesn't preclude them from using the option which is safe for them to properly
I would understand your argument pre-Torres Pagan, and it could be, a very persuasive argument pre-Torres Pagan. What we have to grapple with is the following language in Torres Pagan. It says, quote, "A lawful pat frisk, however, requires more."
Right.
That is, police must have a reasonable suspicion based on specific articulable facts that the suspect is armed and dangerous. What are the articulable facts to show that the passenger was armed and dangerous?
So I think in this case, I think it's almost the same reasonable suspicion that supports that the motor vehicle is involved in the crime is the same.
Isn't that exactly what Torres Pagan
Well,
says we can't do?
I think, I know there's unpublished case that was before this court that actually addressed, I can put in a 16L letter, but said that those two things can be the same. And I think the interesting thing about this case is because we have a different prong, if you will, another justification under Torres Pagan, the third prong, doesn't mean we have to disregard the second. And I think the language that I find difficult with, I think Your Honor saying, is the suspect part. And I think that if it is only two suspects, I think that undercuts what the police are doing. Because if we follow that in this case to its finality, we're saying that the police shouldn't have stopped this car. They should have waited for more evidence. They should have developed it in some other...
No, we're not saying that. I mean, the people in possession of this car are certainly going to be people you want to talk about. At the very least, they'll know, or should know, who had the car 2 days ago. I mean, so you got to talk to them, and you got to look at the car. The question is, under Torres Pagan, can you frisk them?
And I think based on these facts, because Torres Pagan talks about the exit order and that you need something more. It's not just, but I think what Torres Pagan also talks about is what is reasonable under the circumstance. And I think the fact, if this case were to say, this wasn't sufficient for officers to pat for someone before interacting with them, because of course they're going to interact with the people that are in the car. So to suggest that, I think would say that more than reasonable suspicion would be necessary to conduct a pat frisk under these facts. I don't know if I'm articulating that, to say that if this isn't enough for police to say, we need to pat frisk you before we interact with you when we're investigating this motor vehicle that may or may not have a gun that was involved in a violent crime that involved a firearm, I don't know what to say they would need more.
Let's go back to Judge Sachs' question
Sure.
about the limiting principle, though. If it were an hour later, you'd be much happier making this argument. We know that. But it is what it is. It's 36 hours. Where is the cutoff? Is it 36 hours? Is it 1 week? Is it 2? Is it a month?
I don't know, and of course, all these Fourth Amendment cases are so fact-specific driven. And I think I cited some cases in my brief, and I think the way I kind of approached it was more like when we look at search warrants, when the staleness. I know staleness really is a PC search warrant, but when we look at what is stale and what is reasonable to rely on, and I would think in this kind of case, it would be reasonable on the fact that it's a motor vehicle that has the ability to move and transport.
And put the weapon on the body of the person in the seat with the Chinese food, though.
But it does support that the firearm could still be in that car, and that any occupant in that car that the police are going to be interacting with could have either accessed that car, hid it in that car. They could have said, oh no, the police are being stopped, I'm going to hide it on my person. I mean, the hypotheticals are ever-ending, but I think the 36 hours, I think, rises and falls on the fact that it's a firearm that was used in this car. So it's not as if the firearm was used somewhere else, and now we're saying maybe you hid the firearm from the shooting in an apartment, and now you're hiding in your car. That nexus is strong.
Can you differentiate between the two occupants of the car? The police knew that the car was registered to Kayla Evans. They observed that there was a female driver, I think, when the car was in front of the restaurant. Is there more reasonable suspicion, or is there more reason, forget whether it rises to reasonable suspicion, to pat frisk the driver than the passenger? We have no idea whether there was a passenger in the car on the day of the shooting, or whether it's the same passenger.
So I think under these facts, both could be pat frisked, but I think in this defendant, the fact that he has food and his lap is obscured when the police approach.
But didn't they see him just get in the car?
I think that doesn't necessarily dissipate or dispel the officer's right as they engage and ask him to get out of the car. I don't think that totally.
I'm sorry, but the food isn't grabbing me. It might be very tasty.
What if it was not Chinese?
But once they say, give me your food, buddy, I'll put it right here on the roof for you, then he's not concealing anything in his lap anymore. So if you could answer the question, though, about differentiating between the driver and the passenger. Isn't there more reason to think the driver is the same person who was in the car the day before than there is the passenger?
Sure. So I know, I'm going to go back to the food if that's okay. I think the food, I think the food is meaningful here because the police are dealing with probabilities. And I think when they're approaching someone, because again, they're interacting with this person, I think that they're coming face to face with somebody that could have gotten a gun out of the car. And I understand your point, saying once it's gone, is it dispelled? And my point is the officer shouldn't have to rely on that. They should be able to ensure that when they are interacting with this person that is in a car that's involved in a shooting, they should not worry that they're going to get killed when they turn around. And the second part was the driver versus the occupant. And I think in this case that I think everyone would have reasonable suspicion to be pat first before they interact. And I think what's interesting in this case is that at the Bolo, the female owner is acknowledged and known. I think Your Honor saying, hey, we already know she's the owner, or suspect that she's the owner. Does that differ in the calculus of a pat frisk? Is that my understanding? And I think in this case, they're still going to interact with her, so I would think that the same ability to dispel would, in a way, according to my hypothetical, be diluted because she doesn't have food on her lap. But I think the same would be that she would have information likely that either she was in the car because she's the owner. And again, this isn't a rental car. This is something that's known to her.
Well, whether she has information or not, the issue is whether she's reasonably suspected of being armed and dangerous. Do you say that there's no more reason to suspect the driver than there is the passenger in this case?
I mean, I think on these facts, there's less than the defendant. But I think
there's
less than the defendant because of the circumstance. But I do think
because of the food?
Because of the food. But I still think that the fact that the officers are investigating a crime where a firearm was effectuated in that car based on a violent crime, that they would still have a reason to pat frisk her, to dispel safety as they engage with her, because they shouldn't have to worry about whether or not that she took the gun out of the car and they're going to be shot with it while they're properly impounding that car.
There's this odd disconnect between the Bolo and the suppression hearing. The Bolo says the motor vehicle may have ties to Heath Street, and we don't get anything about Heath Street or gang involvement. Any idea why that is?
I don't know why. I mean, I could surmise that Commonwealth has a different burden when we're introducing gang evidence. Sometimes it relies either on multiple police reports or expert testimony. I was not the motion ADA, so I can't necessarily deal, but my prior experience as a trial ADA, I would think that might or may have done with the calculus and decision. I see that my time is up, and no additional questions. I do have one clarification on my brief. On page 18, I attribute a case to Bostic, and that was incorrect. It should be Lopes at 455 Mass 147, 2009. And Lopes is relied on my sister in her brief and numerous points. And the Commonwealth also relied on Lopes and below.
So it was 455 Mass what?
Oh, sure. It's 455 Mass 147, 2009. And my sister relies on it. That's the one with the Cape Verdean flag in the car?
Yep.
Okay. Thank you.
Okay, thank you so much.
Only an hour and 7 minutes till lunchtime.
I'm now wishing I brought Chinese.
All right. Our next case is 22P0526, Murphy versus PNC Bank.
Good morning, Your Honor.
Murphy,
My name
is
is
it?
Rob. Good morning.
Is it Mr. Murphy?
What's that? Excuse me?
Mr. Murphy?
Yes. My name is Robert Murphy, and I'll be representing myself today, Your Honors. Good morning. Just a little background. My wife and I executed a mortgage and a note to National City Mortgage, a division of National City Bank, in March of 2007, and that's shown in the record appendix. Unable to keep up with our payments, we defaulted on the mortgage in 2008. We were notified in 2011 by PNC Bank that the mortgage and the loan were assigned and transferred to U.S. Bank as trustee for Prime Mortgage Trust, Certificate Series 2007-3, and PNC Bank is the loan servicer, and that's also in the record appendix. After some research, I discovered that my loan was securitized along with approximately 600 other mortgages and used as collateral in an offering of residential mortgage-backed securities under the name U.S. Bank as trustee for Prime Mortgage Trust, Certificate Series 2007-3. The offering was structured as a real estate
Mr.
mortgage.
Murphy?
Yes.
I don't want to interrupt you, but we're generally familiar, I think, with the factual background of this case, so I would suggest you get right into the meat of your argument.
Okay. The meat of the argument, I guess, Your Honor, is the court determined most of the counts were resolved around the mortgage, the foreclosure, and they considered it illegal or wrongful because it was the wrong name. They foreclosed on the property on November 16th of 2008. They issued a quit notice in 2019, in January. They filed a summary process complaint in 2019, and I left the property in June of 2019.
So I want to ask a question about the sequence there.
Okay.
So is it accurate to say that you moved out of the home at the time the summary process action was pending?
No, it was in process.
Right, it was in process.
Correct.
And at that time, you were still litigating, in this case, whether the foreclosure was invalid because U.S. Bank didn't hold the mortgage or the note.
Correct.
So you were still fighting whether U.S. Bank had even the right to foreclose, never mind evict you.
Well, I lost the preliminary injunction.
Right, right. But it was the case, the merits of the case were still alive.
That's
so you didn't lose the summary process case. You moved out.
At that point, we moved out and it was dismissed because it was moot.
Right. So are you claiming damages based on having had to move out, where you moved out voluntarily? I mean, yes, while the summary process action was pending, but while you were still challenging their right to evict you, and you went ahead and moved. So I'm curious whether you were saying part of your damages is the fact that you had to move when you were certainly under pressure, that's obvious, but you didn't have to move.
They issued
no
a notice.
Court was saying so.
Correct. They issued a notice to quit. The sheriff never came and kicked us out of our house.
Right, because the summary process case was never adjudicated.
We left before that.
Right. So are you, let me just ask this more simple question. Are you claiming or alleging that your damages include the emotional distress or perhaps the relocation costs or anything else associated with actually moving out? Or is it just the emotional distress of having been foreclosed upon by an entity that didn't have the right to do so?
No, it was the former. Because we were foreclosed,
Both.
we ended up having to move out. We didn't have, the sheriff never came and kicked us out. The summary process was in process at the time. But the damages were emotional distress and the housing and relocation costs and disruption to the family.
So I have one other question, if I could. You filed a summary judgment motion seeking judgment of liability on count 9 alone. That
Correct.
was for intentional or negligent infliction of emotional distress. Where in your summary judgment materials did you provide any evidence that you had emotional distress? Now, I understand your position that if you were seeking judgment on liability only, you didn't have to prove the exact amount of damages. That would come at a later phase if you established liability. But if you don't have any damages at all, then you haven't established one of the elements of your claim. So what was the evidence in your summary judgment motion that you experienced emotional distress?
Well, again, it was my impression that since it was just a liability, the fact that they foreclosed wrongfully or illegally generated the emotional distress, and I would prove that at trial in front of a jury. That's what was my impression. I didn't know I had to prove it, the damages at that point.
So there's no affidavit or medical report or anything else like that
I
in
did
the
not
record
realize I
that
had to do
shows?
that. Right.
So you seem to be suggesting now that in count 9 you were alleging the tort of wrongful foreclosure.
I didn't know what the word tort meant at the time. I thought it was a wrongful foreclosure, and it was damages as a consequence of that wrongful foreclosure.
So why was your count titled intentional and/or negligent infliction of emotional distress, if that wasn't the tort you were trying to allege?
At the time, when the case was brought out, it was just a pending foreclosure. And then it progressed to be an actual foreclosure.
But I thought you didn't add count 9 until after the foreclosure happened.
Foreclosure happened, that's correct. That's correct, but I hadn't moved out yet, right?
Right, so why did you caption an intentional and/or negligent infliction of emotional distress if you wanted?
Well, in the
different
verbiage below, in the paragraphs below, I did mention that it was other damages too. The title is emotional distress.
What do you say your emotional distress was?
Just the embarrassment, the moving out financially, the stress of being kicked out of your house by someone that didn't have a right to do that.
Was there any discussion of count 9 in the hearing in front of Judge McGuire?
Excuse me, Your Honor?
Was there any, in the hearing you had in front of Judge McGuire, was there any discussion of this count, of count 9?
Not in, I don't think a lot of detail, no.
You said you don't, you said,
I don't think there was a lot of detailed discussion about count 9.
do you remember any discussion about count 9?
No, Your Honor, I don't. But I believe Judge McGuire really interpreted the affidavits filed by the U.S. Bank was the cause of my claim for emotional distress, and it was not that those who just showed the amount of negligence involved. It was the actual foreclosure that caused the emotional distress, was the causation. PNC Bank had a history of filing inaccurate foreclosures. I think I go on to say that the U.S. Comptroller of the Currency cited them in 2011 for filing false affidavits and inaccurate foreclosures. And they, in fact, had agreed to correct those. And it looks like they hadn't corrected them. I guess the question is, are the damages because of a illegal foreclosure? Can a rogue attorney go around and start foreclosing on people's property and have no consequence until he gets caught and just void the foreclosures, but there's no consequence for doing that? I guess that's an issue for me.
I assume you haven't reclaimed the house?
No. There's been some damages. Some thieves broke in and damaged the property. I'm not sure if it's even livable right now.
So if I understand the factual situation right, someone out there, some successor of EMC perhaps, holds the mortgage.
So, someone legally owns the mortgage.
Right, but the note has been discharged in bankruptcy.
The personal liability.
Yes.
That's correct. So someone owns the mortgage and has a right to foreclose. It was not PNC Bank and U.S. Bank in 2018, and they illegally foreclosed. And that was what I'm saying is the causation of the damages. Judge McGuire indicated that I never met the 4 elements of intentional or reckless infliction of emotional distress, nor even the 5 elements of negligent infliction of emotional distress. But he was baking everything on those affidavits. The affidavits wouldn't cause emotional distress. They wouldn't cause you to be upset. But it was really the wrongful or illegal foreclosure that was the causation of that distress and the damages.
And what distress is it again? What, if you got to trial, what would you tell someone
I would say
happened?
because of the illegal foreclosure, my wife and I suffered high anxiety, excessive stress, insomnia, nausea, just those type of things, Your Honor. I think it would be a reasonable person would have suffered emotional distress if someone illegally took over their home.
Does anyone know at this point who is the owner, who holds the mortgage on the house?
A few months ago, U.S. Bank, EMC assigned the mortgage to U.S. Bank again and recorded it at the Registry of Deeds. I don't think that's the proper owner either. In the pooling and service agreement, there was a pyramid of a progression of sales, all took place in the same time, just to make it bankruptcy remote and protect the stockholders. So there was a number of transfers. Has it changed since then? I don't know. But I know at that point they were U.S. Bank and PNC Bank were not the owners of the mortgage. Also, on summary judgment, it was my interpretation that the moving party has the burden of demonstrating that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Cross motions, as in the case at hand, must be ruled on each motion independently, deciding in each instance whether the moving party has met the burden under Rule 56. On their cross motion for summary judgment, defendant would need to demonstrate there is no issue or dispute as to the material fact. Defendants did not cite any evidence whatsoever or even address the issue of damages in their cross motion. So in my opinion, the court erred in application of the facts to the law in granting the cross motion for summary judgment to the defendant as count 9. At this point, I would, in conclusion, or in summary, both the defendants, U.S. Bank and National City and PNC Bank, are large national banks conducting business throughout the United States. They have access to high-level, sophisticated legal resources. Most individuals facing foreclosure do not have the ability or the financial resources to challenge these large banks if they believe that foreclosure was illegal. PNC Bank was specifically cited by the comptroller of the currency for their lax oversight in mortgage foreclosures. In the case at hand, I believe U.S. Bank and PNC Bank knew, or at least should have known, the foreclosure and eviction of Murphy from his property was illegal and violated state law, and I believe they should be held accountable for that. I respectfully request the court to reverse the lower court's decision as to count 9 and rule that the defendants' appellees are liable for damages inflicted on plaintiff appellant, in the amount of which a jury will decide at trial. In the alternative, if the court determines that the evidentiary record does not support a finding for either party, then I respectfully request to reverse the lower court's decision as to count 9 and rule that count 9 is denied for both parties and shall be decided at trial. If the court feels that my pleading as to count 9 is unclear, the plaintiff would request the case be remanded back to Superior Court and allow me to amend the complaint accordingly. That's all I have, Your Honor.
Thank you very much. Seeing no questions, we'll say thank you.
Good morning, Your Honors. May it please the Court, Patrick Vogt for the defendant. Your Honor, I won't add much. I think for the most part we'll rely on our papers. I do want to just highlight something that Mr. Murphy said, that that the court considered the foreclosure as illegal and wrongful. Well, what the court found was that it was invalid. Because the power of sale under the mortgage wasn't exercised properly because of the misnomers in the notices that were sent out pursuant to Chapter 244. And I do want to just emphasize that the court had an ample record on which to find that either negligent or intentional infliction of emotional distress were either alleged or factually supported at the time of summary judgment, and that any claim for wrongful foreclosure, which Mr. Murphy didn't argue just now, but is in his papers, then any such claim was waived. It was never pled at the trial court. It was never argued at the trial court. Even when the court issued its summary judgment decision characterizing Mr. Murphy's claims as seeking to invalidate the foreclosure and the foreclosure deed, Mr. Murphy took no issue with that, and he did not appeal a failure of the trial court to make any finding on wrongful foreclosure. He merely appealed the court's decision on count 9.
Counselor, would you agree that in a summary judgment context, the moving party bears the burden of affirmatively demonstrating the absence of a tribal issue?
Yes, Your Honor, by the record. And
all right, so could you tell me where in your papers that you submitted in the Superior Court you did that on count 9?
Well, that would suggest the defendant had an obligation to point out the absence of facts.
It does suggest that. You have a duty to affirmatively demonstrate the absence of a tribal issue. So where'd you do that?
By the documentation submitted to the court as to what the basis for the emotional distress allegations were, affidavits submitted to the court regarding the foreclosure process, As Your Honor knows, the court found that
So where were these affidavits about what the basis of the emotional distress was? I mean, normally you'd think there'd be an interrogatory saying, what's the basis of your emotional distress, and you would attach that. But I didn't see that. Was that somewhere in there?
I don't recall whether it was or not, Your Honor. But I do believe...
Did you depose Mr. Murphy?
I'm sorry, Your Honor.
Depose the plaintiff?
I wasn't litigating the case at that time.
I didn't see a
I don't believe so. I don't believe Mr. Murphy was deposed.
You signed the summary judgment memo, didn't you?
Yes, but I didn't depose Mr. Murphy. Your Honor, I don't think there's an obligation.
I didn't see any discussion in your papers of count 9 at all.
Except that we moved for a summary judgment on it. Your Honor, and in arguing for summary judgment as a defendant, we're simply arguing that there is no triable issue of fact on that. And so I don't believe we had an obligation to point out what Mr. Murphy didn't have. He didn't plead, for instance. He didn't plead the necessary elements of either intentional or negligent infliction of emotional distress.
Okay, but can we really, the motion to dismiss was denied. Can we really affirm on the grounds that that motion should have been allowed?
The motion to dismiss, Your Honor?
There was a motion to dismiss on his pleadings. It was denied. That's not appealable. Now you're saying that there wasn't enough pled, but is that something we can address?
Oh, I believe so, because on summary judgment, Your Honor, the same standard applies. And the court could decide on summary judgment, for instance, that Mr. Murphy had failed to plead that the conduct was extreme and outrageous.
But we don't do pleadings on summary judgment. We do evidence, and the bank was the moving party. So what's the evidence that the plaintiff did not suffer emotional distress?
I'm sorry, Your Honor, what's the evidence that he didn't?
That he didn't, which is...
Well, I don't think that's an obligation that a defendant has to come forward with.
On motion for summary judgment.
To prove a negative.
But you have an affirmative obligation on all elements on a motion for summary judgment. Agree with you at trial.
Well, at trial, there would not be an obligation. The obligation would be on Mr. Murphy.
Right.
So,
and there might have been a directed verdict, but this was a motion for summary judgment.
Right, but Mr. Murphy had moved for summary judgment on the issue.
So
and that certainly gave the court the freedom to look at the summary judgment record in all respects and determine whether or not there was a viable claim for emotional distress, which is exactly what the court did. The court looked at the summary judgment record, what had been pled, and what had been.
His motion is denied because he didn't proffer the evidence, but you're asking for judgment in your client's favor. So now we look at your motion. And where's the evidence that he did not suffer emotional distress?
Again, Your Honor, I don't believe the obligation is on the defending party to prove that there wasn't emotional distress. It is affirmative obligation on the part of the plaintiff.
You had to show...
Ask this. You would only have to negate one of the elements of the emotional distress claim in order to obtain summary judgment. Is that correct?
Correct.
You don't have to show that none of them were present, just that one of them is missing.
Correct.
Did you, even though you didn't address the issue of emotional distress damages or the actual causation of emotional distress, did you address the other elements of count 9 in your summary judgment motion?
Not specific.
That is, whether there was extreme or outrageous conduct, whether it was, I guess, severe emotional distress is one of the other elements.
I believe the defendant's position is that plaintiff had failed to establish that there was any material fact as to their emotional distress claims, that they hadn't pled two of the elements of intentional infliction, nor had they pled two of the required elements of negligent infliction of emotional distress. And therein, you have the absence of pleading, never mind evidence. And so I think the defendant is certainly...
Where did you make that argument?
Yes, Your Honor, sorry.
Where did you make that argument below? Where did you argue, even in the motion to dismiss, that Mr. Murphy failed to plead all the elements of intentional infliction or negligent infliction of emotional distress?
I believe that was at the argument, Your Honor. Not in
That's a good question. So what discussion of count 9 was there in front of Judge McGuire at the summary judgment hearing?
My understanding, it was simply that there's an absence of evidence supporting it, Your Honor. Not specifically with regard to any particular element, but just a general absence.
So at that hearing, you addressed count 9 specifically?
That's my understanding. I didn't argue the hearing. I didn't argue at the hearing. My colleague did. But that was my understanding of the hearing.
May I just point out that in this case and in other cases, Rule 9A in the Superior Court requires a statement of material facts as to which the moving party alleges or claims there's no dispute, and then the other party is supposed to reply to those paragraph by paragraph. I didn't really see that done here on either side. That is very helpful in focusing the trial court attention or the motion judge's attention on whether there is a disputed material fact, and it's very helpful to us on appeal. And it's very difficult to fight one's way through and try to ferret out whether there is an issue out of the mounds of evidence.
I appreciate that, Judge. I understand that, and I appreciate it. But to sort of summarize on this point we've been discussing, I believe the trial court, and I've seen it on not plenty, but I have seen it on occasions where only one party moves for summary judgment, and the court not only doesn't grant it, but enters summary judgment for the other side, because the moving party opens up the record, and the court, the trial judge has a right to look at the complete record before it, not just as to what hasn't been shown, for instance, physical harm or what have you, but to look at the record in this case as to the conduct, the alleged conduct that caused the distress. And that was on full display in the record. There's no issue of fact as to what that was. It was notices being sent out by U.S. Bank to foreclose, and the court found that the notices had the wrong party, that it should have been EMC Mortgage, I'm sorry. And the court found that under these circumstances, that conduct was not the kind of conduct that would satisfy either intentional infliction or negligent infliction, or that under these circumstances, any person would suffer emotional distress under the circumstances. I might add that—
I don't understand the focus on the notices. I mean, it seems from at least the complaint that the complaint is the wrongful foreclosure, not that the notices were bad.
Well, I dispute that the focus of the complaint is wrongful foreclosure. It's that the foreclosure was invalid because it failed to satisfy the statute 244 with respect to the notices. So the notices had to properly identify the party that had a right to foreclose in order to exercise the power of sale.
I thought the judge found that the note still belonged to EMC, and U.S. Bank was just had no right to this property at all. And then you asked for a declaration of that afterwards, that the court declare that EMC is the owner of the property.
Oh, you're speaking of the motion that was filed, Your Honor?
Yeah, afterwards.
Yeah, the motion was filed because that's what the court found in its decision.
It seems like it's more than just notices. It was an actual foreclosure of a property that you didn't have a connection to.
Well, I don't believe U.S. Bank didn't have a connection. The parties believed that U.S. Bank was the rightful party to foreclose. And the parties, the bank did ask the court to essentially clarify its summary judgment rulings in an order that could be filed with the Registry of Deeds. And that motion was withdrawn. But the, Your Honor brought up the notices. The court found that it was misnomers in the notices that was the reason that the foreclosure was invalid. The court didn't find that the foreclosure was wrongful. The court didn't find that the foreclosure was illegal. I believe Mr. Murphy used the words not legal and illegal in his papers, in his complaint. But that was because he was claiming that the notices didn't comply with the statutory provisions. So
the bottom line is that they were forced to move out of their home.
Because the foreclosing party did not hold the mortgage and note and did not act on behalf of the holder of the note in the foreclosure process, the foreclosure is invalid. Well, it says invalid, but I think it means is invalid.
correct.
Nothing about notices.
Well, I think actually the court discusses the notices at length.
In the emotional distress part, but after finding that the foreclosure is invalid because you didn't hold the mortgage on the note.
Well, actually, the court's finding was premised on the notices being in the wrong name. That was the entire basis for the court's decision.
Are we elevating form over substance here? It's not just a typo. It's whether or not the bank had the authority to foreclose. So if they've got the wrong name on the notice, it's because they had no authority to foreclose, right?
Correct.
So we have a case where a foreclosure and summary process was taken against someone by an entity that had no right to do so.
Well, I would remind the court that Mr. Murphy...
Whatever label we put on it.
I understand that, Your Honor. I'd remind the court that prior to the foreclosure taking place, Mr. Murphy had moved for a preliminary injunction, and the trial court, looking at all the evidence, denied that injunction and allowed the foreclosure to proceed. So the foreclosure proceeded on the basis that the trial court essentially gave its blessing to the foreclosure to proceed. So there was certainly a good faith belief on the part of U.S. Bank that it had a right to proceed with the foreclosure, and the trial court agreed with that. So a TRO was given originally, but a preliminary injunction was denied, and I believe we referenced that in our papers.
And was the bank's position at the time that they had the right to foreclose, and was that the basis of opposing the PI?
Well, it's based on the record as well, Your Honor, in the Registry of Deeds. So, I mean, yeah, absolutely, Your Honor, the bank fully believed. The bank is not in the business of putting itself in this position where foreclosure is invalidated or it has to rescind a foreclosure. The bank's been carrying this property for many, many, many years, and the bank is out hundreds of thousands of dollars. And so, you know, the idea that, you know, a bank or any bank would believe they didn't have a right to foreclose and would foreclose anyway, it just isn't in their best interest to do so.
There's a difference between recklessness and intentional behavior and negligent behavior. We know that.
Sure, but
the problem is, yet here we are.
No, I understand that. But I do believe, I see my time is essentially up. Does the court have any additional questions? All right, thank you, Your Honors.
Thank you very much. That concludes our in-person arguments for today. We'd like to thank our court officers and our clerks and our interns and all of our IT staff and everybody who makes these hearings, both in-person and virtual, possible. Hearing is concluded.
All right.